Good evening, Doc Raswell. Good evening, everyone. Our group will tackle employee relations, advanced conflict resolution, negotiation, and labor relations. I'm Christian Escaño, and my presentation will explore on the collective bargaining processes and setting my current company, Abbott Laboratories, as an example. On the other hand, my group mates Maku, Spencer, and Manuel will discuss the negotiation preparation, bargaining tactics and strategies, and agreements on labor contracts. Let me provide you an overview of the collective bargaining. Collective bargaining is a critical process in labor relations that involves negotiations between employers and the representatives of employees, often unions, to establish terms and conditions of employment. My presentation explores the collective bargaining processes, examining the roles of various stakeholders, negotiation strategies, and the impact of effective conflict resolution. According to International Labor Organization, collective bargaining is essential for maintaining harmonious labor relations and ensuring fair treatment of workers. It allows employees to have a voice in determining workplace conditions and provides a mechanism for resolving disputes. Let me share a notable case involving my present company. In a notable case in 1996, Abbott Laboratories faced a legal challenge from the Abbott Laboratories Employees Union regarding union registration and collective bargaining rights. The union filed an application for registration with the Department of Labor and Employment, which was initially approved. However, Abbott Laboratories contested the registration, arguing that the application did not meet the required criteria, such as signatures from at least 20% of the rank-and-file employees. The Bureau of Labor Relations, or BLR, initially canceled the union certificate of registration, but this decision was later reversed by the BLR's Appellate Division, upholding the union's legitimacy. Abbott Laboratories then appealed to the Secretary of Labor, who declined to review the BLR's decision, stating that the BLR's decision was final and not subject to further appeal. Later, the Supreme Court ruled that the Secretary of Labor and Employment does not have jurisdiction to review the decisions of the BLR in cancellation cases, and that the decisions of the BLR in cancellation cases are final and unappealable. This case highlights the complexities and legal challenges that can arise during the collective bargaining process, especially concerning union legislation and the rights of employees to organize and negotiate collectively. Abbott Laboratories has learned a lot from this case, and as a result, Abbott Laboratories changed the way it does things, especially in terms of employee relations, focusing on the long-term relationship with its employees. In preparation, both parties gather information, define their goals, and develop strategies. This phase involves researching industry standards, financial data, and past agreements. At Abbott, it involves the following goals. The union representing employees aims to secure better wages, benefits, working conditions, job security, and other employment terms. On the other hand, management seeks to maintain operational efficiency, profitability, and flexibility in workplace management while addressing employee concerns. The actual negotiation involves presenting demands, discussing issues, and making concessions. Effective negotiation requires communication, compromise, and problem-solving skills. At Abbott, negotiations occur in a series of meetings where both parties discuss their proposals, make counter-offers, and seek common ground. If negotiations reach an impasse, a neutral mediator may be brought in to facilitate discussions and propose solutions. In some cases, arbitration may be used, where an arbitrator reviews the dispute and makes a binding decision. The use of mediators has sometimes been necessary to resolve complex disputes and facilitate mutually acceptable agreements. Once an agreement is reached, it is documented in a collective bargaining agreement or CBA. The CBA outlines the terms and conditions of employment, including wages, benefits, working hours, and grievance procedures. In fast negotiations, Abbott Laboratories and the union representing its employees have engaged in collective bargaining to address various issues, including wage adjustments, health benefits, and job security. The negotiated agreement is presented to union members for approval or ratification. Once ratified, the agreement is implemented and both parties are responsible for adhering to its terms. At Abbott, ongoing communication and cooperation are essential to ensure the smooth implementation of the agreement. Let's proceed to the negotiation strategies. These are the types of negotiation strategies according to International Labour Organization. Interest-based bargaining. This approach focuses on mutual interests rather than positions. It promotes collaboration and problem solving to achieve win-win outcomes. Then, we have positional bargaining. This traditional approach involves each party taking a position and negotiating towards a middle ground. It can lead to adversarial relationships but still commonly used. Note that clear, honest, and respectful communication is crucial for successful negotiations. Active listening and empathy help build trust and understanding. Negotiation strategies at Abbott Laboratories typically involve a combination of interest-based bargaining, effective communication, and strategic planning. Abbott Laboratories often emphasizes finding common ground and mutual benefits rather than sticking to rigid positions. This approach helps in creating win-win outcomes for both the company and its employees. On the other hand, the International Labour Organization has mentioned two conflict resolution techniques, namely mediation and arbitration. In mediation, a neutral third party helps facilitate discussions and propose solutions. Mediation is voluntary and aims to help parties reach a mutually acceptable agreement. In arbitration, an arbitrator reviews the dispute and makes a binding decision. Arbitration is often used when mediation fails and when parties agree to this method in advance. Conflict resolution at Abbott Laboratories involves a variety of techniques aimed at addressing and resolving disputes effectively. Abbott Laboratories offers conflict resolution training programs for employees and managers. These programs equip individuals with the skills needed to handle conflicts effectively. The company has also a formal grievance procedures outlined in the CBA. These procedures provide a structured process for employees to raise and resolve grievances. Grievance procedures typically involve a step-by-step approach, starting with informal discussions and escalating to formal mediation or arbitration if necessary. At Abbott, the focus is on the long-term relationships. We emphasize the importance of long-term relationships helps in maintaining a positive and cooperative work environment. Trust and mutual respect are key to effective conflict resolution. Abbott also encourages a collaborative approach to problem solving fostering a sense of teamwork and shared goals. To conclude, exploring the collective bargaining processes highlights the importance of effective negotiation and conflict resolution in maintaining positive labor relations. By understanding the roles of various stakeholders and employing strategic approaches, parties can achieve agreements that benefit both employees and employers. Thank you.
Preparing for collective bargaining negotiations. So first, select negotiators. Choose the people who will negotiate and assign them roles. Second is plan. Set up strategy meetings, decide on a time and place, and know the law. Third is research. Learn about the other side, including their standing with their members and the company's ability to pay. Next is to analyze. Assess the strengths and weaknesses of the current contracts and review other collective bargaining agreements. Next is gather data. Find economic data on wages, benefits, and other compensations. Understand the cost. Know the cost of the contract, including the cost of unsuccessful negotiations. Be prepared. Come to the bargaining sessions with good data and a positive attitude. So in our company, A Plus Falcons Freight Incorporated, so we are engaged with the customs brokerage, freight forwarding, and domestic tracking. So to relate this in our office, when we have a certain issues or scenarios with the employees or even with other people outside our organization. So the first thing we do is to select a negotiator who will negotiate with a particular person. So meaning to say, we have to assess first, or we have to know the exact scenario, and then after knowing the exact scenario, so we will choose among our team. So basically in admin or even in the human resource department. Second is to plan. So after selecting a negotiator, of course we should have a strategy meeting, so wherein we will discuss the matter, we will discuss how we will resolve it, and we will discuss, of course, the pros and cons of the decisions. So after that, we have the research. So we're in here, we will do the research about a specific scenario. So the disadvantages, the advantages, what will be the outcome, or what are the opportunities for us, or even what decisions should be taken or shall be made in that particular case. Then we have to analyze. So here we will identify the strengths and the weaknesses of the current contract. So lagi naman kino-consider which one is advantageous with the company. Gather data. So in gathering data, it is also important. So ngayon we have the current scenario wherein with the employee, dahil dito malaking tulong siya sa pag-gather ng data, kasi at least nakakatulong siya sa office to decide, or with the human resource, no. So if you don't have the data, if you don't have the figure, so you cannot strategize. And then understand the cost. So in doing the previous one, which is the gather data, it is interconnected with the understand the cost, because sometimes dun lang din natin nalalaman yung mga ano ba yung monetary implications ng mga magiging decisions natin. So it is really important na malaman natin yun para makapag-render tayo ng good decisions. And of course, be prepared. So prepared meaning to say, nakapagkanda ka na nga ng data, you have the data also, and then nagkaroon na kayo ng prior meeting with your team, so that during the negotiations, you are really prepared. And lastly, you should have a positive attitude. Thank you.
Okay, good afternoon, everyone. My name is Zidaudo Emmanuel, and I'll be talking about bargaining tactics and strategies. And without wasting much of your time, we'll just dive right into it. So, brief introduction about it. Bargaining tactics and strategies play a pivotal role in conflict resolution and negotiation within human resources management. In HR, the goal of negotiation is often to find a fair and balanced solution that satisfies both the employers and the employees' needs, while maintaining positive relationship, minimizing long-term conflict. Successful negotiation in HR involves a combination of tactical approaches, physiological insight, and strategic decision-making. And below, I'll try to break down some of the key bargaining strategies and tactics used in conflict resolution and negotiation within the HR. So the first one will be preparation and information gathering. Strategy involved here would be preparation is the key to any negotiation. Both sides needs to come into the table with clear objective and understanding of the issues and relevant data, such as the salary benchmarks, legal requirements, or the performance metrics. And still here, we'll have some tactics that could be employed, which would be research the other party's interests, goals, and possible constraints. This helps to have clear goals and alternative, often called the BATNA, which means best alternative to a negotiated agreement. The more you know about the alternative, the more confident you can find to be in your negotiations. And then the second one would be building a rapport. The strategy here would be establishing a positive relationship early on to help create more cooperative atmosphere, trust. It's a cornerstone in the negotiation. And then strategy employed here would be, or the tactics employed here would be, to use active listening techniques, show genuine interest in the other person's position, and then reflect back their concern to demonstrate understanding. Start with small, non-contentious issues to build goodwill, which can help pave way for more difficult decisions. So the third one would be anchoring. Strategy. The strategy here that would be employed would be anchoring involves setting an initial offer or position, which serves as a reference point for the rest of the negotiation. And then the tactic employed here would be, if you are the employer, starting with an offer that's reasonable but slightly higher than your actual target can shift the negotiation range in your favor. The other one would be, if you're representing employees, counter with an offer that is realistic but give room for negotiation. And a tip just there would be, avoid extreme anchors that can alienate the other party. Instead, aim for the reasonable, defendable position. And we have the fourth one to be framing. Strategy employed here under framing would be, the way you present an issue can significantly influence the way it is perceived. Framing negotiations in a way that appeals to both sides' interests can be highly effective. And the tactic employed would be, frame proposals in terms of mutual benefits. For instance, if you're negotiating a salary increase, frame it as a way to improve performance and employee retention, which benefits both the company and the employee. Reframe potential objection. If any employee is worried about the company's budget constraints, highlight how investing in talent retention can lead to long-term savings. And we also have number 5 to be concessions and then trade-offs. Strategy negotiations is often about give and take. If you have something, you may need to make occasion. It is important to approach occasions strategically to maintain upper hand. Tactics would be avoid making unilateral concessions that weakens your position. Always try to ensure that you are getting something in return. Number 6 would be silence and patience. Strategy employed here will be, silence can be a powerful negotiation tool. It forces the other party to fill the gap, often revealing the more information or making concessions out of discomfort. The tactic here will be patient during pauses. Sometimes the other party will offer more than you expect if you give them time to think. Win-win or win-loss. The strategy in most HR negotiations, the ideal outcome is a win-win, where both sides feel they have gained something of value. However, in certain situations, a win-loss approach, such as in salary negotiations, might be more appropriate, especially if one party has much leverage. The tactics here for the win-win approach would focus on creating value, such as offering non-monetary perks, while the win-loss approach would be, if the negotiation is about a limited resource like salary, focus on securing the best possible deal, but be mindful not to burn bridges for future negotiations. And on the 8th one, we have use of third parties. We have mediation and then arbitration. Strategy: when negotiations stall or become particularly contentious, involving a neutral third party, such as a mediator or arbitrator, can help facilitate resolution. And then the tactic employed here will be, if there is no room for compromise, an arbitrator can impose a binding decision which helps when all else fails. Managing emotions, which is on the 9th one. Managing emotions. Emotions can often play a major role in HR mediated negotiations. Managing both your own emotions and emotions of others is crucial to maintaining productive negotiations. And on number 10, we have escalation and de-escalation. And then strategy employed here would be knowing when to escalate or de-escalate a situation can be a key to finding a solution. And number 11, we have the ZOPA, which means Zone of Possible Agreement. Strategy. ZOPA refers to the range in which both parties can find common ground. If no such zone exists, it may be better to walk away rather than push for an impossible agreement. Then number 12, we'll have building long-term relationship. The strategy here will be the goal of the HR negotiations often extends beyond the immediate issue at hand. It is about maintaining long-term productive relationship between the employer and the employee. And the tactics employed here will be to maintain an open communication after negotiations and continue to listen to feedback from employees to prevent future conflict. Conclusion here will be an HR management, successful conflict resolution and negotiation are critical for creating a healthy workplace culture. The key to balancing the interests of both the employer and the employee while fostering mutual respect and understanding. Effective bargaining tactics and strategies such as careful operation, framing, empathy, and patience can help achieve outcomes that are satisfactory to both parties and contribute to long-term organization success. By honoring these skills, HR professionals can become more adept negotiators, turning potential continuous situations into opportunities for cooperation and its growth. Thank you very much.
Lastly, allow me to discuss the agreements on labor contracts. A labor contract is a crucial document for both employees and employers, which it would be providing clarity, protection, and a legally binding framework for the employment relationship. How is it important? Let us discuss these three key aspects. First, it is for employee protection. A labor contract safeguards employees by clearly outlining their rights, duties, and benefits within the employment relationship. It ensures that the workers are aware of important terms such as wages, working hours, job responsibilities, and any other conditions that impact their well-being and job security. For instance, provisions regarding sick leave, vacation time, and workplace safety are commonly included to protect the employee's personal rights and ensure a healthy work environment. Additionally, the contract can protect employees against unfair treatment, such as unjust termination or changes to critical job conditions without prior notice or agreements. Secondly, it's a legally binding agreement. One of the most important aspects of the labor contract is that it serves as a legally binding agreement between the employer and the employee. Once both parties sign the contract, they are legally obliged to adhere to the terms outlined within it. This provides a legal framework for resolving disputes, ensuring that both parties understand their commitments. If either party fails to uphold their part of the bargain or their obligations, whether it's failure to pay agreed wages or the breach of confidentiality, the other party can take legal action. The contract also helps prevent misunderstanding by making the terms of employment clear and enforceable in court only if necessary. And lastly, it will be providing clarity. A well-drafted labor contract provides clarity for both employees and employers by establishing the clear expectations. It sets out specific details about the job roles, job work hours, compensations, benefits, and even conflict resolution procedures. This clarity helps prevent future disputes or confusions over the interpretation of terms, creating a more transparent and harmonious working environment. For example, if an employee is unclear about their duties or their scope of positions, the labor contract can serve as a reference point, reducing misunderstandings that might otherwise lead to dissatisfaction or even legal challenges. A labor contract is not just a formality, but it is a vital tool that protects employees, ensures the agreement is legally binding, and provides clarity for both parties. By doing so, it fosters trust, stability, and fairness in employment relationships, contributing to the positive and productive workplace. Let's take this example. This is a Pacquiao agreement between the DPWH and also the contracting party. Clearly outlined in this first column, the first page, all the responsibilities that are provided on how they would carry out the work. Also, written is the memorandum of agreement or acknowledgement for both parties to agree on the terms and conditions laid out on that Pacquiao agreement. It is something that is very common in the Philippines, and even DPWH are imposing or are implementing this kind of agreement. Other specifics are already provided there as well, with the schedule of work hours, on how it would be done per day. And what is very good in this agreement is this on this part wherein there is an acknowledgement of all those concerned that this agreement is a Pacquiaoan agreement. What I find striking in this one is that it is written in their native language, which is Cebuano. It is really good to ensure that the language written in this is very acknowledgeable or knowledge or within the knowledge purview of those who agrees into it. And also written on those other part are the specific areas on how they're gonna be working and where are they gonna be working on the specific areas. So for me, this example is a clear example of how labor agreements are to be done. Now that we've established that labor contract agreements are really important, we should understand what are the key aspects of these labor agreements. Whenever we draft an employment contract here in the Philippines, it is essential to include specific details to provide clarity and legal protection for both employer and employee. These key elements help ensure a smooth working relationship and reduce the risk of disputes. For example, a job description and the role. A clear and precise job description is crucial as it outlines the employee's duties and responsibilities and the scope of its works. This section sets expectations about what is required of the employee on a day-to-day basis. Including a well-defined role helps prevent misunderstanding and ensure that the employee knows what is expected of them in terms of performance. It would also provide clarity for the employer in case there are performance issues or disagreements about the job responsibilities. The description should cover not only primary tasks but also any specific goals, targets, or outcomes that the employee should strive to achieve during the course of employment. Next, I think this is one that's really important for all of us: compensation and benefits. This section should detail the agreed upon salary, payment frequency, whether it be weekly, bi-weekly, or monthly, and any applicable bonuses or commissions. In addition to the base salary, benefits such as health insurance, retirement plans, allowances for food, transportation, or any other in between, leave entitlements such as sick leave, vacation leaves, maternity, and all other similar types of leaves should also be included. The contract should specify the conditions under which these benefits will be availed, as well as any deductions that may apply, such as for taxes and insurance premiums. Clear compensation and benefits clauses both ensures that parties understand the financial terms of their employment relationships. This is another funny part wherein for us in the government we call this OTY. So parang overtime na thank you. This aspect is what we call work hours. The contract should specifically state that the employee's working hours, including the days of the week and the daily hours worked. In the Philippines, however, the standard work week is 40 hours, di ba? Usually broken down into an 8-hour days with 1 hour lunch. However, the contract should specify that whether employee is expected to work overtime in like what I've said a while ago, sa amin, sa government, we call that OTY. How overtime is compensated, for us it's TY. Additional pay or compensatory time offs, and any conditions regarding flexible working hours or shift work. Having clear terms on work hours helps to avoid disputes related to scheduling and compensation whenever overtime is allowed. During the pandemic, the government implemented flexible working hours through the civil service circulars. This allowed us to work from home, or even work from home, or in time we will be working a 3-day work week with 2 days off, or also a compressed work week. So those are the types of things that is applicable for us, to those who are working in the government. Last, another one is the duration of employment. The contract should specifically whether say what type of employment it should be. So it could be a permanent position, a contractual, fixed term, or just have a specific period of time. If the contract is a fixed term, the contract should indicate the start and the end of the contract. In case of an indefinite term, the contract should outline the terms of that termination, either by the employer or the employee, and the required notice period. It is then common for us to have a 30-day notice period before our resignation. Fixed terms contracts are common in project-based and seasonal employees, while indefinite contracts are known for permanent employment. Specifying the duration clarifies the expectations for both parties and provides transparency regarding job security. Another is the grounds for termination. It is vital to include these grounds because termination of an employment contract is something that we hope doesn't happen. However, in the Philippines, the labor code specifies just causes such as misconduct, insubordination, gross negligence, and other authorized causes such as retrenchment, business closures, and the like in terminating employment. The employment contract should specify both employers' and employees' rights to terminate the contract. The required notice, like what I've said a while ago, is about 30 days, and any severance pay or benefits in case of termination. The grounds for termination should also outline any procedures to be followed, such as an investigation or due process, to avoid wrong termination claims. This clause helps both parties understand their rights and obligations in the event of termination. Ito yung mga common that we see employees going to Tulfo to justify that they are wrongfully terminated. However, Tulfo is not the answer. You always go to the National Labor Relations Commission in order to do the arbitration for you before filing of cases happen. So that's where it starts. And that's as far as I can say about those radio stations or agencies who try to help, but at the end of the day, they are really just referring to the correct agencies. Lastly, confidentiality and non-compete clause. To protect the employer's business interests, many contracts sometimes includes confidentiality and non-compete clauses. A confidentiality clause, it would ensure that employees does not disclose any sensitive company information such as trade secrets or proprietary data during or after the employment. Confidentiality is specifically important in sectors like finance, technology, research, where access to proprietary information is critical to business success. The clause should define that constitutes confidential information and the period for which the confidentiality obligation remains in effect. On non-compete clause, this prevents employees from joining on or starting a competing business for a specific period, usually about 6 months to a year, and within a particular geographic area after leaving the company. Non-compete clauses are intended to protect the company's market position and prevent the employee from using the knowledge gained at the company to benefit a competitor. While these clauses are enforceable in the Philippines, they should be reasonable in scope and duration to be upheld in court. Including these key details in an employment contract is not only ensures that there's a compliance with the Philippine labor laws, but also protects both the employer and their employee. Clear terms around job description, compensation, work hours, duration of employment, grounds for termination, and confidentiality provisions help avoid misunderstandings, providing legal safeguards and foster a productive working environment is really important for a successful employer and employee relationship. Both parties should review their contract thoroughly before signing to ensure that it reflects their understanding and their agreements. For academic purposes, allow me to share my position description form. This is basically what I signed for when I entered the Philippine Air Force as a civilian human resource. So clearly, based on the topics that I was discussing a while ago, here are the aspects that is provided for. First is the salary grade, my position title, which is an Administrative Officer 3 or a Supply Officer 2, with the salary grade of 14, shows that I am under the Department of National Defense under the Philippine Air Force. Also, where do we get my salary? Is from the General Appropriations Fund. So basically, ako po ay isang lingkod bayan at nanggagaling po ang aking sweldo mula sa inyong mga taxes. And my place of assignment is in the Edwin Andrews Air Base, Air Force in Zamboanga City. And my position is a counterpart of a non-commissioned officer in charge. So basically, it's supervisory in nature. So it is a civilian supervisor that to whom I am directly under. So basically, that is what's written there. So what are my qualification standards? Actually, in the government, qualification standards for the position that I have is relatively achievable for all. So it doesn't necessarily mean that I should be an accounting student or accounting graduate to be a supply officer. It only states that I should be a bachelor's degree holder. And also, I have a 1 year of relevant experience, which my relevant experience is with logistics, with my former company, Coca-Cola FEMSA, and also I had 4 hours relevant training, and I have a career service professional second level eligibility. During that time, the career service professional career service exam is it's not something that people look forward to, but now nakikita ko it is becoming a trend among those new graduates. I took my civil service exam in 2008 after I finished college, and at that time hindi pa gaano siya big deal eh, pero now I see even review centers have a civil service exams reviews. So ngayon talagang nagiging importante siya, maybe because there are more and more people wanting to join the government. So like what I've said a while ago, it should outline the specifics of what I am supposed to be doing. So here as my core competencies, which are integrity, excellence, professionalism, interpersonal relationships, and communication. So basically, our competency level is from 1 to 5. So what is expected of me is on a level 3 competency level. So that's my core competency. Within the nature of work that I have at the moment, these are the things that they look forward. Next, on the core competencies, because of being in the public service, that's what is expected of me. Another is a leadership competency, because I am on a supervisory level. I am expected to manage my performances, to develop people, manage change, conflict management, problem solving and decision making, and also come up with strategic management. As a supply accountable officer, I provide information to bosses, which are military in nature, on how we are to handle our supplies, on how we are to properly book our equipments, and how are we gonna dispose it. So basically, the whole cycle. I am tasked to be that person to provide the correct and detailed information on how it's gonna be done to avoid COA AOM. So AOM is audit observation. Um, Audit observations. So that's basically one part of my position description form. And lastly, it would talk about my technical competencies. So, first, critical thinking, supervises property procurement, act as custodian. So, these are the specific things that are already expected of me. So, it's already written there whenever in the time frame on how I'm going to be supposed to be doing that. So, at the 8-hour work that that I am supposed to be doing, these are the things that I'd be providing service to the Philippine Air Force. However, katulad nga ng sabi ko kanina, may hindi nakasulat diyan. Ano ang hindi nakasulat is yung fine print eh. Well, it's not really written there, but it's just a running joke among us that, you know, to provide other tasks directed, to provide functions tasks directed by the commanding officer or the commanding general. So those are the things that are not written, but bilang malasakit at pagmamahal mo sa iyong trabaho, ginagawa natin to. Di ba sinasabi nga natin, may mga ligaw na utos, may mga overtime na OTY, yan ang mga hindi nakalagay dyan. Pero, dahil mahal natin ang ating trabaho, ginagawa natin yan para sa ikabubuti ng ating bansa. Here at the Philippine Air Force, we are commanded by orders. Hence, whenever we are promoted or we are accepted in the Philippine Air Force, we have special orders released for us. So, here are the sample of people that are under those times wherein we were promoted, and the specific item number from the Civil Service Commission. So also, this is the sample of the CSC form number 33B, which says that this parang ito yung diploma namin that hinahawakan namin, that whenever we're promoted or accepted in the government, this is the one that we keep to ourselves. Na this is the basis of our item on why we are working here in the government and why we are performing all our tasks provided. Labor contracts in the Philippine setting are essential tools for establishing clear, transparent, and legally binding relationships between employers and employees. They play a pivotal role in defining the terms of employment, ensuring protection for both parties, and fostering a harmonious work environment. By clearly outlining key details such as job responsibilities, compensation, work hours, grounds for termination, and confidentiality clause, labor contracts help mitigate potential disputes and misunderstanding which can lead to costly legal battles or damage working relationships. In the Philippine context, labor laws robust protections for employees, ensuring fair treatment, job security, and access to essential beneficiaries. However, these protections are most effective when complemented by a well-drafted employment contract that aligns with both legal requirements and the specific needs of the business, whether for permanent, contractual, or project-based employees. A properly structured labor contract helps manage expectations, ensures compliance with the labor code, and provides a mechanism for addressing issues that may arise during the course of employment. Ultimately, a well-crafted labor contract serves as a foundation for a productive, legally compliant, and mutually respectful relationship between employers and employees, fostering trust, reducing conflicts, and contributing to overall workplace stability and success. Both parties should take the time to carefully review and negotiate the terms of the contract to ensure that their rights and obligations are clearly defined and protected under the labor law. Thank you and good evening.